All right, we are on the record outside the presence of the jury, all parties, well, at least several of the parties representing counsel on both sides are present, and the defendant is present. Last night, a motion was made for Rule 29. The court heard arguments, and the court is now prepared to render its decision.
I'm sorry, but I would object to going forward anyway right now without the elected county prosecutor who's on this case.
But she chose not to be here.
That's not accurate, Judge.
Okay, okay, your objection's noted.
We had a phone status conference 2 weeks ago in which Ms. Schiffel...
Your objection is noted. Okay?
I'm not going to participate in this proceeding without the elected county prosecutor. I think this is a sham that you're going forward. When the court was...
You're going to sit here. You're going to sit here.
You were told about her unavailability and specifically told her on the phone not to cancel that appointment, that it wouldn't be a problem.
Well, I'll tell you what. If you want to be here for the decision, that's your business.
Well, Your Honor, I think this is outrageous. You're going forward without the prosecutor.
I have prepared my remarks and my decision here today, and I am, I am glad I had the opportunity to spend the night to do some deliberation on this matter and think about it. But I want to kind of begin with a sidebar before I go to the motion itself. And it's an apology I'm going to make to the defense team here. Before you made your motion, I made a few statements that were probably an effort at humor, but I think they could have been interpreted as intemperate, unnecessary, or perhaps even offensive. And that was certainly not my intention. And I likewise did not in any way try to imply that your motion was simply a matter of the record and an administrative act, and perhaps without merit. And I say that not only because that wasn't my intention, but your arguments were well-spoken, compelling, well done, and very professional. And in fact, I want to say that both lawyers have been professional throughout this entire case. So you're the kind of lawyers that any judge would want on his or her docket trying a case. And I want you to know that. And I regret a lack of reciprocal professionalism for that moment there, and I wanted you to know how I felt, and I wanted to share that with you. It's not reflective, I hope, of who I am.
Thank you.
The court, as I said, has had an opportunity to consider this case for a significant period of time last night, and I note that in my 20 years both as a sitting judge and a visiting judge, I have rendered decisions on Rule 29 motions in every criminal case, and I've denied those motions and I have granted those motions. But I think I can say this has been the most difficult motion for me to consider. And again, I'm glad I had the time to reflect upon the arguments made by counsel. And I think probably one of the reasons it's difficult is that both the state and the defense have made very compelling and good arguments. Perhaps it's more the state of the evidence presented that I'm working with that I've had to spend a lot of time thinking about. I want to begin this decision by saying what is not a part of the court's consideration. I am not judging the credibility of any of the witnesses who testified, nor giving weight to any of the witnesses, nor in any way whatsoever injecting my personal opinion, if any, as to what I would think the state of the evidence is. I am certainly not considering this case on the standard of beyond a reasonable doubt. As we all know, the standard is to look at the evidence in the light most favorable to the state without any of those other considerations. And the court has done so, and my job, if you will, is to determine whether or not there's evidence in which jurors could come to even different conclusions, but one which would be a decision in favor of the state. Now, I have already indicated, and I reaffirm at this point in time, that the state has amply satisfied its burden in regard to the motion, in regard to the establishment of this being a homicide and a staged suicide. With that determination, following that, a vast majority, if not the great majority of the elements of murder, both purposeful murder and felony murder, as well as felonious assault, are satisfied by that finding by itself. The issue that's primarily before the court is the question of the identification of the perpetrator who has committed this homicide and staged suicide from the evidence. What probably has made this case most difficult is that there is no direct evidence establishing the defendant as the perpetrator in this case. Now, the state is not legally required to do that, but it does enhance the decision process at this time to be more circumspect. Clearly, as the state has acknowledged as well, that circumstantial evidence is the cornerstone of this case. And the inference reasonably raised from the evidence that in a natural and logical way would follow and according to the common experience of mankind as to what those inferences are drawn from direct evidence is what the court must look at. And I think consistent with the requirement that the court look at the evidence in the light most favorable to the state, the court must also look at the inferences in the light most favorable to the state. So, the court has considered the circumstantial evidence provided. The state has, I believe, and perhaps a bit ironically, established the question of motive. The defendant is married to the deceased. The evidence is presented that they've had chats and messages to each other that have been classified as difficult, argumentative, including one not to each other, but one on May 7th where the defendant declared that his marriage was over. Evidence that 2 weeks prior to the argument, there was testimony that there was a very loud argument in their garage. Statements made that are inconsistent with some of the facts determined by law enforcement, and misstatements or even lies made to police. And of course, evidence in regard to the argument that Mr. Moore made statements in the past tense, which inferentially is that the speaker would have known that even though the deceased was not discovered, she was not going to be discovered alive. This kind of is the evidence that demonstrates that the defendant could very well have been unhappy and angry with his wife, and the behavior after he reported her missing could circumstantially infer that he knew something that he was not telling the police. The state also presented evidence, largely through the digital forensic evaluation of the defendant's cell phone, which, as we all know, reflects the usage activity and non-user activity of the phones, that reflected for approximately 3.5 hours on the evening of May 24th and the morning of May 25th, that there was no activity for which time period any acts of the defendant were unaccounted for. Now again, several inferences may be drawn from that, certainly, but the inference most favorable to the state is that he could very well have been engaged in the conduct that resulted in the demise of his wife. The argument presented by the state, based upon the evidence presented in its totality, is that, again, under the rule, the court has made the finding that this was a homicide and staged suicide from the evidence in the view most favored to the state. And the question raised from that evidence, by working from that, is who would be a perpetrator, who would take the time and necessity not only of ending the life of an individual, but taking the effort to stage it so it would appear to be a suicide. Now, we obviously know, and the evidence reflects, that within 48 hours, the police provided the Miranda rights to the defendant. So he certainly began this case as a person of interest upon whom suspicion would fall, and that's virtually the case every time when a spouse is missing or is found to be a victim of a homicide. Certainly, circumstantially, based upon that evidence, based upon the conclusion that the court's finding that this is a homicide and staged suicide, is also rather consistent with the thought that the evidence provided the fact that suicide over a significant period of time has affected the difficulty in the lives of both the defendant and his wife, which likewise has a bearing upon why that could very well have been staged by her husband. Again, at this time, considering all of this evidence and in light of what the court has preliminarily addressed regarding the nature of the court's decision, I find at this time that taken in total, the state has met its threshold burden to allow this matter to be considered by the jury, and thus the Rule 29 motion presented timely at the close of the state's case will not be granted. The court will simply state for the record at this time, and particularly since we are coming to the close of the state's case due to our unique agreed circumstances, that the court on its own motion is going to take under advisement a Rule 29 motion at the conclusion of all of the state's presentation of evidence, and will proceed accordingly. Now, with this decision, we are now at the point where I guess we should take this opportunity, if you wish, to go over jury instructions. Are there any, is the state ready or willing to discuss jury instructions at this point?
Yes, Your Honor, I am. Thank you.
All right. What would you, what changes, deletions, additions, or corrections would you
Okay. Oh, now they're on to jury instructions. Ooh, that was dramatic. Starting with the prosecutor walking out of the courtroom because the elected prosecutor in the county was not present. And then just the way the judge was going down that road, it seemed like, oh, was there a chance that this judgment of acquittal, this motion, would be granted? Turns out it wasn't, which is usually the case. But what is not usually the case is all this drama. Usually it's a quick, oh, thanks for the motion, not happening, and move on. Let's talk about it. Adam Stone and Maria Barlow's with us. Maria's been with us all morning. Joining our conversation is Adam Stone. He's in Bucyrus, Ohio. Adam, your thoughts on what we just watched?
So, you know, generally speaking, like you said, it's a pretty quick up and down motion that is standard. I mean, it's always made at the conclusion of state's evidence. But in this case, I think because there's so much circumstantial evidence, the judge really took the time and the thoughtfulness, really very thoughtfully made a record as to why he was denying the defense's motion. But in doing so, I think he kind of drew everyone's attention to, or at least everyone in the gallery, to the great weaknesses of this case that we've been talking about since the outset.
Yeah, and Maria, he brought up the one thing that you know, we have been talking about here on Court TV is that, yeah, the suicide angle here is only half of the equation. At the end of the day, it's very, you know, people could say, yes, this was a staged suicide. She didn't commit suicide. She was murdered. But who murdered her? And where's the evidence that it was the defendant? Of course, he's the as the judge pointed out, he's suspect number one, and he had the access, but it's also part of the equation, and he brought that up. Your thoughts overall, though, of what we just watched, including the prosecutor getting up and walking out?
Like you said, it was all very, very, very dramatic. I definitely was on the edge of my seat, especially when he said, the defense, your arguments were compelling and persuasive. I was like, whoa, is he about to grant this? But I think in addition to the type of case that this is and the circumstantial evidence, I think that he felt bad about whatever joke he told or whatever comment he made. So that made him do a more thorough job as to going through a bigger analysis and just to kind of cover himself and let the defense know, hey, I truly didn't just dismiss you. I actually went through everything, and here's what I found. I don't want you to think I just blew you off.
All right, well, that was very dramatic for a morning, first hour, but it was something else. And the whole sideshow of the prosecutor getting up and walking out was a totally separate issue. I was thinking, boy, do they have some sort of insight on how this is going, and they're upset? But no, it seems like that was just a separate issue that the state was upset about. At least the second chair was upset about getting up and leaving.